The Administrative Department of Security, thus, is the Secret Service Agency of Colombia, which receives financial support from the United States through the Plan Colombia, an agreement signed between the two countries with the purpose of achieving social and economic revitalization, in addition to ending the armed conflict and drug trafficking in Colombia. This entity is in charge of all tracking and the subsequent capture of all those required in extradition. In the present, the DAS is being investigated for serious problems of corruption, exceeding its functions, and frequent complaints for abuse and irregular behavior. Even the Supreme Court of Justice, Human Rights Watch, opposition parties, and the media were victims of their abuse. Almost anyone can get an extradition warrant. There are practically no requirements. All you need is a verbal note that is sent by the U.S. government. It has been already pre-established in a computer format. It's 2 pages, and it says that the person is required in extradition. So there's a capture warrant because it is considered an urgent matter. They're guided, escorted, and supervised by the U.S. agents in Colombia, who have practically no limits, don't have any control at all, and they're protected by the law. Illegality in the process starts with the illegality in the capture. Their communication is restricted, their feeding is restricted, their health care is restricted. I am a personal witness of the case of 2 people convicted for extradition who have died within their cells. And that is because the INPEC didn't grant them access to appropriate medical treatment. They just wouldn't dare getting them out of prison and taking them to a hospital. And the way they treat people that are convicted for extradition is even worse than the one given to the most dangerous felon in Colombia. Even though the Attorney General of Colombia found serious irregularities on the physical infrastructure of the Convita prison after the last inspection of District 7, such as insufficient bathrooms in poor condition, and near the dining halls, no water supply for human consumption or cleanliness, deficiency on alimentation and healthcare services for the inmates. The situation goes on and gets worse progressively, risking the inmates' integrity with disease and infection.
They should review our processes. They must study them. They must verify the processes. And that way they would realize which people they have on District 7, what kind of people are on trial. I never knew what proof they had against him. At least 10 denouncements have been made. 2 NGOs, to the International Court for Human Rights. We presented all the requirements to the Supreme Court, and all of them were denied.
It is alarming to know that the people that are convicted for extradition can spend in jail from 12 through 36 months waiting for the government's decision to be extradited or not, even if they don't have any process in Colombia or any previous criminal record and no guarantees controlled judge as established in the political constitution of Colombia. The worst nullity that can occur in a legal prosecution is the lack of defense, the lack of means and mechanisms to defend their non-extradition pretension against the Colombian state. There is no doubt, freedom in Colombia is forbidden. And it is forbidden because if any official grants innocence, will become investigated.
No evidence of innocence of this person is valid for national authorities, because they say the proof must be validated by foreign justice.
Colombia is a country of law, but law is not applied here. The political constitution of Colombia establishes fundamental rights for everyone. And of course, the people that are captured for extradition are Colombian nationals. They just don't have a different skin or a different condition, and they're treated like that. It is worse being required in extradition than having been prosecuted legally in Colombia for 2,000 murders. Many human rights organizations, control entities, and professionals in international law recognize the violation of social, economical, cultural, civil, and political rights on extradition processes. More than 20 articles of the Colombian political constitution are violated, and about 10 of the Universal Declaration for Human Rights. The first violated guarantee is the guarantee of a process. The right for contradiction and defense is null. The right for a judge of guarantees, as it was mentioned, doesn't exist. The right or principle of protection of liberty, the right to life, the right for presumption of innocence, etc., etc., etc. Even though extradition in Colombia is considered a mechanism of cooperation in between countries, it's not really a double-way process. There was a great controversy in the case of the denial of extradition of Jair Klein, citizen from Israel. That was the European Court decision because he could be a victim of human rights violation in Colombian prisons. Klein was prosecuted in Colombia for terrorism and conspiracy, and he is well known for having worked with Pablo Escobar and the paramilitary groups that for decades committed the most atrocious slaughters of thousands of Colombians. Months after having sent her plea to the Supreme Court, Selene received a reply.
Regarding the matter, I respectfully let you know that extradition is a legal cooperation mechanism that intends to avoid impunity of felonies committed on national territories of the country that is requesting the extradition process. There is another part here that reads, hence, the documents you provided cannot be applied within the extradition process carried on in Colombia. It is important to inform you that as soon as the extradition process begins, all required citizens directly or through his attorney can apply his right for defense in terms and opportunities established by the law. Here they say they're providing all the rights to Hermes and all the wants to be extradited, and that's a lie.
In Colombia, the Supreme Court of Justice, Criminal Appellate Division, doesn't perform any probatory analysis. It obviously denies to the extradition candidate the right to receive all proof of innocence through his attorney.
I'm afraid they can convict him just to avoid the fact that he can sue them. Or maybe they could offer him an arrangement. It works like this. Okay, you are convicted for conspiracy. We know that you don't have any charges for drug shipping. They have no support. Charges for conspiracy give you some time in jail. You spend some time in Convita, you spend some time here, so sign here and you can go home. This has happened to many people. He signs, it exonerates the state from a suit, he's sent home with no money and his social life totally destroyed.
He had a trial at the United States. He had to declare himself guilty and they would give him 10 years. He said, "Why should I declare myself guilty? I'm not guilty." And because of that, they gave him 21 years.
It's really unfair. Sometimes you see guys caught with all the evidence of what they have done, and they only get 3 or 4 years in jail. So why him? With no evidence? And he was sent for such a long time.
They didn't accept our complaints at the Chancellery because they said he was a recidivist. And in the trial documents, you can see that he didn't even have a previous criminal record.
We feel totally unprotected by our government. We need help, because neither Colombia nor the United States want to help us. I said that for me and for many people that are going through the same situation. I know this is happening because there are claims on the web. This is not something we're making up. The problem is real. The damage is real. People need help. They must review the cases, not only his case, all of them. Because there are lots of people convicted just because someone said they were involved, or because he worked with or walked next to someone. You never know who's next to you. It's a good thing that through you we have this little space in which we can be heard.